Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to talk again about the case of Duncan v. Bonta, a challenge to California's magazine ban, which is back on remand before a full panel of the Ninth Circuit. And even though between the time they first heard this case and thought it was totally okay, and the time they've reheard the case, the rules have completely changed. Well, the result has not. We're going to show you just how disingenuous and dishonest and intellectually dishonest the Ninth Circuit is. We're going to bring the receipts today to prove it. So today, let's spend a few minutes and let's talk about the rotten Ninth Circuit upholds magazine bans again. Okay, America, we're talking about magazine bans, and specifically we're talking about the case of Duncan v. Bonta. Now, we have talked about this case before because, as I mentioned in the intro, this case is actually older than our YouTube channel. Now, I'm going to go through what the court found here, okay? But before we go there, I want to go back in our time machine for a minute because I mentioned in the intro that this case had once before been before the Ninth Circuit. That's right. It had been before a full en banc panel of the Ninth Circuit. This was pre-Bruen, okay? Now, I went back, decided to take a look at the case summary from Duncan v. Bonta 2021. And this is what I found. The court applied a two-step framework to review the Second Amendment challenge, asking first whether the challenge laws affects conduct protected by the Second Amendment, and if so, what level of scrutiny to apply. The court noted that 10 sister circuits had adopted a substantially similar two-step test. The court assumed, without deciding, that California's law implicates the Second Amendment, and joining its sister circuits that have unanimously applied intermediate scrutiny to other laws banning or restricting large capacity magazines determined that intermediate scrutiny applied because the ban imposed only a minimal burden on the core Second Amendment right to keep and bear arms. Applying intermediate scrutiny, the court held that the law was a reasonable fit for the important government interest of reducing gun violence. Okay. But I want you to focus on this, that California's law implicates the Second Amendment. And remember, because the ban imposed only a minimal burden on the core Second Amendment right to keep and bear arms. Okay, so I think it should be very clear from the Ninth Circuit's previous ruling that the Second Amendment was absolutely, positively implicated in a magazine ban. But guess what, America? Guess what they have ruled this time around? Yeah, they have ruled that the Second Amendment does not even apply, that magazines are not protected by the Second Amendment. And then just to pile it on, they Rahimi'd us. So I'm going to go through what they did here. The court begins this way. Mass shootings are devastating events for the victims, their families, and the broader community. The first mass shooting in the United States occurred in 1949, and they have increased in frequency and in lethality primarily because of widespread availability of modern firearms technology. Okay, so when the court starts with that as its very first words out of its mouth, you know where we're going, okay? And this is where the Ninth Circuit went. Large capacity magazines are optional accessories to firearms, and firearms operate as intended without large capacity magazines. A large capacity magazine is thus an accessory or accoutrement, not an arm itself. Possession of a large capacity magazine therefore falls outside the text of the Second Amendment. Okay, so you see the sudden departure that the Ninth Circuit took from its previous ruling in order to get to where they wanted to get on this one, which was the same conclusion, but they had to use a different method to get there. The court even explained it this way. Plaintiffs assert that their proposed conduct, possessing large capacity magazines, implicates the text of the Second Amendment because, in their view, large capacity magazines are arms commonly chosen for the purpose of self-defense. And I'm sure that is not their argument. It is that they are commonly owned for all lawful purposes, including self-defense. The court went on to state, defendant raises several distinct arguments to the contrary. Large capacity magazines are not arms within the meaning of the Second Amendment. They are not in common use for self-defense. They are most useful in military service, and they are dangerous and unusual. But ultimately, the court really didn't have to get into any of that because they took the easiest off-ramp from this argument. Because remember, if the text of the Second Amendment applies, then the government is going to have to justify it through the use of historical analogs. Knowing that there aren't any out there, what's the court going to do that wants to uphold this gun law? The following. But the text of the Second Amendment also reveals an important limit on the scope of the right. In particular, the amendment protects only the right to bear arms. At the time of ratification, a clear distinction was recognized between weapons themselves, referred to as arms, and accessories of weaponry, referred to as accoutrements. And the Ninth Circuit just basically shoves this off as saying this is really no different than any other type of accessory. Many optional accessories, such as a high-powered scope for a rifle, a gun sling, or a silencer, may be attached to a firearm without necessarily falling within the scope of the text of the Second Amendment. So ultimately, even though the Ninth Circuit clearly ruled on Duncan v. Bonta Part 1 that the Second Amendment was implicated, on Duncan v. Bonta Part 2, suddenly the Second Amendment is no longer in play. But just to rub a little bit more salt into our wounds, the court decided to go a little bit further and say, well, let's just say, for example, the Second Amendment does apply. The ban is still upheld because there's a rich history to support it. And you go, well, what's that rich history? I'm not familiar with any comparable bans. Well, there wasn't because, you see, we got Rahimi. Right? Yeah, that's right. You know, that old, more nuanced approach, more relevantly similar. That's exactly where the Ninth Circuit went with this. But, you know, for some of my fellow content creators out there who thought that maybe Rahimi wasn't going to be that big of a deal, I will remind you all I was kind of standing alone on an island saying, no, this is a really, really big deal and this language is going to get shoved down our throat. And this is about the 8th or 9th video where I've talked about that language getting shoved down our throat. The court ruled here, we readily conclude that a more nuanced approach is appropriate here. This case implicates both unprecedented societal concerns and dramatic technological changes. And so with that more nuanced approach, where suddenly apples become the equivalent of oranges, the court has found that laws on gunpowder storage, that laws on trap guns, and that laws of banning possession of firearms by violent felons all justify banning high-capacity magazines or magazines which hold more than 10 rounds from lawful, responsible American citizens. The court has found that the test here is not in common use, but in common use for self-defense, even though I cannot seem to find that case law anywhere. So at the end of the day, America, one of the reasons I didn't rush to get this video out is because I didn't think there was anything really newsworthy about this. We kind of knew that when the Ninth Circuit decided to just suck this up en banc from the 3-judge panel without letting them even get their fingerprints on it, we knew where this is going. And it has proven to be exactly as we predicted. But here's the thing. Never in a million years did I think that a court would be so intellectually dishonest as to the first go around to say, absolutely, this constitutional amendment is applied here. And on the second go around to go, no, actually, on further review, it's not even implicated here. Well, that begins to show the political and the intellectual dishonesty that permeates the entire Ninth Circuit. Okay, the case once again is Duncan v. Bonta. We're going to link it up down below. You guys know the drill. 3 fingers of bourbon, breathing exercises, or a barf bag. You're going to need it to get through it. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.